Can you make a direct I-130 filing at your local consulate if your intending move date is a year or more? Maybe. Stay tuned to find out more. Hi everyone, this is Jonathan Chow, immigration attorney based in Washington, D.C. If you're a U.S. citizen living and working abroad and you need to move back to the United States on short notice, for whatever reason, you might be able to file what's called a direct I-130 filing at your local U.S. consulate. Doing so will allow your foreign spouse and children, most likely stepchildren, to gain permanent residency more quickly, skipping over the usual lengthy, slow channels. We've done a video that discussed this type of filings at length a few months back. If you're interested, go ahead and look at the description box and click on that link. And once you're done, come back because I have some stories and lessons to share. Again, the central question for today's video is, can you make a direct I-130 filing at your local consulate if your intending move date is a year or more? If we review the relevant provisions and policy manuals that concern this type of filings, we will notice a lot of words like imminent and short notice, but no specific definition of what short or imminent means. So, I've never had to ask this question before because most of the clients who come to me with this request to file this type of petition tend to need to move back to the United States in a couple of months. That all changed a few months ago. A client based in China approached me to see if I could make an exceptional circumstances filing on their behalf with the consulate in Guangzhou. The wife is a U.S. citizen in this situation. The husband is the foreign national. The wife received a job offer from an American employer with the job start date slated for a year from now, a year from then when they approached me. So their question to me was, hey, is this time frame short enough for an exceptional circumstances filing? And my answer to them was, I don't know. I've never had to face this situation before. On the one hand, 1 year is not 1 month or 2 months. On the other, if they go through the usual channels of filing the I-130 with USCIS and then have the case transferred to the consulate in Guangzhou, after all said and done, it's going to take about a year and a half. This is not going to be fast enough for their intending move date. The wife might have to delay her job start date, possibly losing this job offer, or she might have to move to the United States before her husband. So we're going to experience a bit of a family separation here. They need to maintain 2 households. Their child is still a toddler, so who's going to take care of the child in the meantime? It's going to be a nightmare. So certainly if you look at things that way, the circumstances seem exceptional enough to justify a direct I-130 filing with the consulate. My advice to those clients was, let's try, right? We don't know what the precise definition of short notice job transfer is, so let's just ask the consulate. If they say, go ahead, they will schedule an interview for the U.S. citizen wife, and then we can proceed from there. If they say no, then we can at least understand that this is not an option, and we can begin processing with USCIS as soon as possible and minimize the time frame of that family separation. Sounds like a good plan, right? So after giving them that advice, we submitted a request to the U.S. consulate in Guangzhou. The typical way is to submit an email to a designated email address. We need to tell them that, hey, the husband and wife will both be in China to complete this processing. They have not submitted the I-130 with USCIS. And then I gave a very lengthy explanation of their circumstances. I let the consulate know about their intending move date, which was a year from then. And I let them know why exceptional circumstances warrant a direct filing in this situation. Lo and behold, 2 weeks after submitting that request, we received an interview notice from the consulate telling the wife to go to the consulate and complete the I-130 interview. Now, this would tell me that somebody read the email and decided that the situations were exceptional enough as to warrant that direct filing, right? So we prepared the I-130 form. We prepared the required documents for the wife to bring to the interview. And on the day of the interview, after speaking with the officer, she confided to the officer who was interviewing her that the intending move date is a year from now. and how would they schedule the subsequent interview for her husband so that the immigrant visa will still be valid by the time they need to travel? That's a good question, I think. You want to know how the process is going to be completed so that there's no hiccups, right? And then to her surprise and my surprise, I wasn't present at the time, but my client told me after the fact, the officer straight up told her, no, 1 year move date from today is not imminent enough to fit the exceptional circumstances requirements. Now this is just hearsay at this point, so I have no way of verifying this. Apparently the officer also told my client that imminent has to be 3 months. Of course, it's hogwash because there's no relevant case laws and provisions of the law to talk about what precisely imminent means. And of course, any person with any common sense would understand that this is a ridiculous outcome. If the consulate reviewed our original request via email and scheduled the interview, that means someone at the office has read our request, understood the client's situation, and then scheduled the interview. Why waste our time by having us attend this interview only to tell us in person that this intending move date is too long? At this point, we're in a bit of a bind. The most conservative and safest option is to just say, okay, well, direct filing is not going to work, so let's go through the USCIS route instead. After discussion with a few experienced colleagues from AILA, we've decided that a reconsideration request might have a slim chance of working. And this is where me, the lawyer, comes in. I typed out a very lengthy reconsideration request talking about, again, the exceptional circumstances that my client experienced. I talked at length about the hardship that they would suffer due to family separation if they go through the USCIS route. And in a somewhat subtle way, I also let the consulate know, hey, they screwed up, because they really did. The reconsideration request was sent via the same email where I would usually make a direct I-130 filing request with the hope that someone is going to actually read the reconsideration request. And 1 month passed, 1.5 months passed, and I thought, well, we have to pull the trigger on USCIS filing or it's going to be way too late for my clients. As a last-ditch effort, I actually sent a follow-up email to Guangzhou. I don't know if any of them ever read those emails, to just go, hey, have you taken a look at our reconsideration request and what do you think? And to our surprise, it finally worked. The consulate responded to my follow-up email. My clients are scheduled for subsequent interviews, well on their way to complete the direct filing with the consulate in Guangzhou. So what are some lessons that we can learn from this experience? Well, the first lesson is that the consulate in Guangzhou is far from perfect. Certainly the internal communication needs a lot of work. Otherwise, we wouldn't have found ourselves in that particular situation. Second, somebody actually does read those emails in detail. Despite my disappointment with the initial request to make the I-130 filing, somebody actually took the time to look through the reconsideration request, I don't know, a couple thousand words there, in order to decide whether or not they should change the decision on our case. There is no formalized process for reconsideration, but apparently sending this request through the email actually worked out. An equally important lesson is to not bring up novel issues at the I-130 interview, because the officer who is doing the interviewing is most likely not acquainted with your particular situation, so bringing up your novel questions is only going to increase the chance of them denying your case. And finally, I think the most important lesson here is that if you're able to make good enough argument in support, you can actually succeed with exceptional circumstances filing, even if your intending move date is a year from now. And that's it for today. I want to thank you for listening. Since the beginning of last year, our firm has actually taken on quite a number of exceptional circumstances filing cases. I never planned on it, but it's slowly becoming our forte. This is a mechanism, again, a way for a citizen to bring close family members into the United States more quickly, provided that their circumstances are exceptional, including, as we discussed today, if the US citizen needs to move back to the US on a short notice job change. So if you or someone you know think you need help in this particular area of immigration law, please contact us and we would be more than happy to help you. Okay? Have a nice day.